Okay, welcome. We are now going to be starting the subject of federal civil procedure. If you understand what civil procedure is all about, it's about what distinguishes you lawyer-type people from the rest of the world. Torts is something that intuitively makes some sense to people who never went to law school. Torts is about what happens when people have accidents. Contracts is about what happens when people make promises and break them. Criminal law is about when people hurt each other in a way that offends society. Those kind of make sense to people intuitively. And when you came to law school, torts fact patterns intuitively made sense to you, right? Civil procedure is different. It's lawyer's law, pure lawyer's law. What court has jurisdiction? What court has venue? What claims can be joined? What claims must be joined? What parties are necessary and indispensable? What's required for a class action lawsuit, and so forth. These have nothing to do with the experience of ordinary human beings in the real world, but they're pure lawyer's law. So, as lawyers, you want to be conversant and comfortable with this stuff, okay? Number one. Number two, I would say, American civil procedure, and also to some extent civil procedure in other common law countries, is totally different from civil procedure. I said this with evidence law. We have our evidence law on account of the jury. We have our civil procedure, a lot of it, on account of the jury. A lot of what is our civil procedure would be totally different if we did not have the potential of a jury trial. It's like, how do we keep cases from getting to the jury? How do we get ready for the possibility of a jury trial, even if we're not going to have a jury trial? So we're going to see over and over and over again, you make sense out of this by, do we get to the jury or do we not get to the jury? What do we have to do before we get to trial? There's not that radical division of stages in civil law systems. But starting off, I said, if you have a dispute and you go to a lawyer's office and you have a story and then, what's going to happen? Well, why do we have government in the first place? And I tied this into when I was explaining that this was a capstone course in the law, kind of a different way of thinking about it. Everything comes together here. Everything from your whole legal studies career come together into one great big package. So it's not like in your first year you had a course in torts over here, and a course in contracts, and a course in crim, and a course in civil procedure. And they were just separate courses with separate exams. And occasionally the professors might refer to things in the other areas. I'm saying this is a package. That's the bar exam. And if you think about it that way, think about it as a whole. There are rules of behavior. Society has rules of behavior. Torts, how we're supposed to behave when there's not a contract. Contracts, how you're supposed to behave when there's an agreement. Property, how you're supposed to behave in relationship to claims to land. Basic areas that people have disputes about, what are the rules of conduct? But the rules of conduct would mean nothing if we didn't have some way to implement those rules if there's a dispute. A and B have a dispute as to whether B violated one of those rules of tort law or rules of contract law. We need somewhere to go to have a dispute decided. That's civil procedure, right? It's there for all those substantive areas of the law with those rules. Criminal law, we have criminal procedure. How do we apply these rules to actual behavior? And then evidence is that glue that ties it out to the real world. In the procedure, how do we use evidence to prove whether we violated the rules? It's all one great big package, and all under that wonderful umbrella of our United States Constitution, which allows for the system. It's all one package. So you look at the system of procedure as a timeline from beginning to end, and as you're reading through the rules and reading through the outline, just think of it as a timeline from beginning to end, starting with who can we go to resolve our dispute? Who can we go to? We need someone with the power or authority, and that's called jurisdiction. And we have jurisdiction in two big and totally different senses that we study in this course. One is the jurisdiction or the power to require the defendant to show up. That's called jurisdiction over the person, right? Plaintiff goes to the decision maker and says, hey, I would like you to decide my dispute with Mr. Jones. So plaintiff is saying, yes, you have the power, you have the authority, I recognize your jurisdiction. But how does the decision maker get to assert power over Mr. Jones? That's the law of personal jurisdiction. What are its limits and how is it carried out? But in addition to personal jurisdiction, we also have a concept called subject matter jurisdiction, because we may have a court that has power to require the defendant to appear, but does that court have the authority over the particular kind of case that's involved here? And we're not going to look at different state courts in terms of their subject matter jurisdiction. We're only going to look at the subject matter jurisdiction of federal courts, because that's a special thing. So when do federal courts have subject matter jurisdiction, and when do they not have subject matter jurisdiction? So those are our two big headings: personal jurisdiction, which you need in both a state and a federal court, and then subject matter jurisdiction, which we will only talk about in terms of the rules of federal courts. I'm going to come back in more detail in a bit. But once we have a court with jurisdiction, we still have to get the case started. We have to get the ball rolling. Hey, I know what court I want to go to, but how do I get the defendant involved? And so we have a series of things that have to take place between now and the potentiality of a trial and a judgment. First, I've got to let the defendant know that he is being sued. Service of process. How is service of process done? To assert that jurisdictional power that I say I have. The federal rules provide for service of process. State law provides for service of process. We serve process, which means a subpoena. You must show an appear and a complaint. We're just beginning our dispute, resolving our dispute with a complaint. We have things that are called pleadings, and you need to know the names of the pleadings and what they're all about. And in the federal system, which is what we're talking about, the pleadings are extremely simple. They used to be very complicated. At common law, you had pleading after pleading after pleading. In the federal rules, you have two basic pleadings. You have the complaint and you have the answer, and occasionally a reply. That's it. Simple, not very technical, but you want to study what must be in the plaintiff's complaint in a federal court. It has to state the basis of subject matter jurisdiction, it has to give notice to the other side of what the case is all about, and state what relief you're asking for, basically. It's really very simple and straightforward. And then what needs to be in the answer, study that. You need to be aware of it, right? That's the complaint and the answer. And then you might say, well, what might happen next? Well, let's just keep it really simple at this point. If I have one plaintiff and one defendant, it might be that other people have some interest in this dispute. And so the question would be, can I join other people? Can we have more than one plaintiff and more than one defendant? What are the rules of joinder? And we'll talk about those. Those are important. You'll have rules of when it's permitted to join parties, when it is necessary to join parties, when it is permitted to join more than one claim as part of the same case, or when it is permissive, when it's required. Now we know what the case is all about. The pleadings tell us what the case is all about. Remember, that tells us what evidence is going to be relevant. We look at the pleadings to start with. And we know who all the parties are because we've finished our joinder. Now, until relatively recently, the next thing would be we'd go to trial. Or we'd hire an investigator to investigate, but that would be the end of the formal system. But now we have this huge thing called discovery, which did not exist as such in federal common law until the 1930s. Since the 1930s, this has become an expanded, massive part of federal civil procedure, the rules of discovery. Before we go to trial, the sides will exchange information. They're required to disclose certain things, and then they can ask each other certain things through various methodologies. Discovery. All the methods of discovery are testable, but probably aren't going to be more than 2 or 3 questions on the whole bar, not a huge amount of questions. When we finish that discovery process, we have one of our critical things called a motion for a summary judgment. You've all have heard of a motion for summary judgment, right? Motions for summary judgment have appeared on the MBE for the last 40 years. Even though they said we don't test civil procedure, they tested civil procedure in the sense that they would put into a multiple choice question, plaintiff makes a motion for summary judgment, should it be granted, right? All you need to know at a starting point is summary judgment will be granted if there is no genuine issue of material fact. And the party seeking judgment is entitled to judgment as a matter of law. Law versus fact, you see. Because the purpose, the theoretical purpose at least, of having juries available is juries are there to decide the facts. They're not there to decide the law. Judges tell the jury what the law is. Juries will decide disputes of fact. And if there is no dispute about any material fact, then there's no purpose in having a jury. The judge can decide the case just applying the law to the undisputed facts. So the defendant very often would like to get a summary judgment So he never has to go in front of a jury. Because if I go in front of a jury, who knows what they're going to do? They might come back with a judgment against me for $5 billion. If I can get summary judgment, I never go in front of that jury at all. That's all leading up to trials, because if I don't get a summary judgment now, the next step would be to go to trial. In the United States, and this is really not true in most of the countries now that follow English common law, we use the jury trial more than is used elsewhere. You have a constitutional right in a federal court to a jury trial in a criminal case, and you have a constitutional right to a jury trial in a civil case. The constitutional right to a jury trial in a criminal case is both federal and state. But whether there is a constitutional right to a jury trial in a state court is up to the states. That's not imposed on the states by the United States Constitution. But in a federal court, you have a right to a civil jury trial in cases when the amount of controversy exceeds like $20. Well, what is that? That's everything, right? You have a right to a civil jury trial if you choose to. That's how important the people who set up the United States thought the jury trial was as a way to keep to use the word that we might use today, to keep the establishment from having too much power, to bring the people into the process of deciding really important disputes. And so during the jury trial, there are all sorts of specific motions that can be used to cut the jury trial short so that we don't ever get to the jury. At the end of the plaintiff's case, plaintiff puts on all of its evidence, and the defendant says, gee, I think the plaintiff failed to put on evidence from which any reasonable jury could find for the plaintiff. There is an element that they had to prove, and they put on no evidence in support of that element. And so they make a motion that used to be called a demurrer and then was called a motion for a directed verdict, and now is called a motion for a judgment as a matter of law. What's the difference? There is really no difference, right? It was called a directed verdict, meaning as if the judge was going to say, ladies and gentlemen of the jury, I want you to go off to the jury room and I order you to come back with a verdict for the plaintiff or for the defendant, but don't think about it, you have no choice. Well, that's silly, right? So if the judge is saying there's nothing for the jury to decide, we will give a directed verdict, the judge just is going to enter the judgment. So they finally updated the language, and it is now, in modern terms, called a motion for a judgment as a matter of law, meaning we don't need a verdict at all. We don't need a directed verdict, no need for a verdict. At the end of the plaintiff's case, there's nothing to go to a jury. Okay, so the defendant made this motion for judgment as a matter of law. Now at the end of the judge turns it down. At the end of the defendant putting on its evidence, the plaintiff makes a motion, give me a judgment as a matter of law, because no reasonable jury could find other than finding for me. Pretty rarely is a plaintiff ever going to get that. Judge denies it. Jury comes back with its verdict. Be clear on the language. Juries give verdicts. They don't give judgments. Judges give judgments. Verdict is just the decision of the jury about what the facts are and what the conclusion should be. Once the jury has given its verdict, there are several options still. I should go back to before the jury gives its verdict. I'm sorry. Let me just add one other little thing to our timeline. I'm going to go back over this timeline a few times. At the end of plaintiff's and defendant's evidence, the judge is going to instruct the jury about what the law is. Because how are they going to go off to the jury room to decide the case without knowing what the law is? And they didn't go to law school, so the judge is going to tell them what the law is. And the judge's instructions about the law are where law gets made. What is the law? What should I instruct the jury? Anyway, so the jury comes back with a verdict. After that, the parties can still make post-trial motions. One of those post-trial motions is a motion for a judgment, a renewed judgment as a matter of law. It used to be called a judgment notwithstanding the verdict. Now it's a renewed judgment as a matter of law. Judge, you let this case go to the jury, but the jury came back with a verdict that's totally crazy. The facts don't support it, so you should give judgment to the side that lost, even though the jury went the other way, because the jury was crazy. Or, Your Honor, you should give us a new trial. This trial that we had was so defective in some important way that we should get to do the whole thing all over again. Okay? If the judge denies the new trial or denies the JNOV or the judgment as matter of law, now we're ready for appeal. Appeal, general rule, cannot happen until we get final judgment, the final judgment rule. Now we can appeal, and on appeal we have various standards of review that you need to be aware of. And assuming that the appellate court affirms what happened at the trial court, we now have final judgment And there's nothing more to do except to take that judgment, which is just going to be a piece of paper with words on it, and enforce it. And if it's a judgment for money, you enforce it by having the sheriff or the appropriate person seize property and sell it, right? And suppose that it's a judgment by a court from the state of Florida. You can take the Florida state court judgment and you can take it to Georgia. You can take it to Missouri. You can take it to Washington or Oregon or Pennsylvania and say, I have a judgment against John from the Florida state court. He has property here. Grab it, take it, and give it to me. Or sell it and give me the proceeds. And the courts of all the other states must give full faith and credit. Here's where the Constitution comes in. Full faith and credit to the judgment of a sister state. So as long as Florida had jurisdiction to decide the case, or if there might not have been jurisdiction that was litigated and found that they had jurisdiction, now there's nothing left to adjudicate in Oregon. Just take the judgment from Florida and attach the property that the defendant has here in Oregon and have it sold and give the proceeds to the plaintiff. That's the full faith and credit clause. So that's one of the effects of the final judgment. We get something that can be enforced. But another effect of the final judgment is we have these doctrines that used to be called res judicata collateral estoppel, but are modernly called claim preclusion and issue preclusion. And that means the matter has already been decided once, and you can't start a second lawsuit about the same thing, about the same claim. You can't sue at all, or even relitigate an issue that was involved in that case. Once the case has been finally decided, time for appeal is run, final judgment, then issues that were decided in that case cannot be relitigated in a later case. If that issue is involved in a later case, the court must use the holding on that issue from the earlier case. And any opinions that were given by the courts in this case turned out to be precedent for later cases. And we are done. That's the law of civil procedure. Now see, that's not so bad, is it? The rest is just a whole lot of detail on this little timeline, right? The timeline being first, we have to pick what court or courts we might bring our dispute to. Subject matter jurisdiction, personal jurisdiction. Then we've got to actually initiate the case, service process, pleadings, exchange, information in terms of pleadings with other parties, join whoever might be part of this dispute together, go through a process of discovery leading up to a summary judgment motion or a trial, go through a trial, get a final judgment, appeal it or not, get final judgment, and now we're done. It's a timeline from beginning to end. Now, let's go a little bit more slowly, because obviously they're not going to ask you questions as simple as that, right? How do we decide what court? We could start by looking either at what's called personal jurisdiction or at what's called subject matter jurisdiction. It doesn't much matter which. They are both going to be tested on your exam. So since you're going to have 28 questions in Federal Civil Procedure, Jurisdiction and Procedure, of those 28, from what they've said, you should have 6 or 7 of them should be on jurisdiction and related matters. That's not huge, but it's not trivial, right? It's a lot of material to cover with 6 or 7 questions. Personal jurisdiction is what you studied in your civil procedure class. I'm sure you studied it. If you remember the names, Pennoyer against Neff, International Shoe, minimum contacts, and all that kind of stuff, which is what I taught for the first 20 years or 25 years of my teaching career, over and over and over again. In Pennoyer against Neff, the old granddaddy case in this line of cases, the Supreme Court said that a state had the power in its courts to take jurisdiction over a person who was present in the state and served while he was present, or had property in the state that was grabbed as a basis of jurisdiction. If you went into the state of Oregon and they served you with process, here's the papers, you were now subject to adjudication in the state of Oregon, even if you left afterwards, even if that's the only time you ever went there. As long as you were present and served with process, they had the power to require you to appear in their courts and defend. See, they didn't have to arrest you and hold you. They could just serve you with process once you were served. Now, if you chose not to show up and defend yourself, tough luck. You just lose. But if you chose to show up and defend yourself, they would issue a judgment, ultimately, that would get full faith and credit in all the other states. So Pennoyer at the simplest level, stands for the proposition that to get power over the person of the defendant, see, the plaintiff chooses the court. There's no problem with power over the person of the plaintiff who chose the court. Power of the person of the defendant if the defendant was served while present in the state. Caveat, not if served while lured into the state by some kind of trickery. There are occasional times when you could be lured when there wouldn't be jurisdiction. But other than that, basically jurisdiction when you were served in the state. This got expanded in terms of traditional bases for jurisdiction. State would have jurisdiction over anybody who was served while present in the state, anybody who is domiciled in the state. So what's the difference there? If you are domiciled in the state of Florida, it is your permanent home, but you may have left and you may not be available for service. So I'm domiciled in Florida, but I go away for years and years and years to elsewhere, but I don't change my domicile. As long as I'm domiciled in Florida, Florida can adjudicate anything having to do with me, period, because this is my domicile. Number three, the state can adjudicate over anybody who consents to the state's jurisdiction. They show up and they defend. Then there's jurisdiction. Or they can appoint an agent in the state for service of process, either voluntarily or because the law requires it. What states started to do in about probably the 1910s, 1920s, was pass statutes that said anybody who drives into our state, onto the roads of our state, by using the roads of our state, appoints the Secretary of State of our state as his agent for service of process. So if you use the roads, you already have an agent. You get into an accident, we serve the Secretary of State who mails it to you. So, service while present, domiciled, consent, having an agent in the state are all traditional bases for jurisdiction. But we get up to the 1940s and the world is changing. People are moving back and forth a lot more than they were 50 years earlier. And a company named International Shoe has this interesting way of doing business. They want to sell shoes all over the United States, but they don't want to be subject to lawsuits all over the United States. So they do not have stores all over the United States. They do not have employees all over the United States selling shoes directly. They have, this is what they carry around a bunch of one shoe from a pair. Now, unless you have only one foot, one shoe from a pair ain't going to do you much good, is it? They carry around one shoe from each of the kind of styles they've got, and people can try them on if they like them. The order gets sent back to the factory, which is in Missouri, and the factory in Missouri will ship you a pair of shoes in the state of Washington. Well, Washington wants to impose a tax on anybody who does business in the state of Washington. And they say International Shoe is doing business in the state of Washington, but we can never serve them while in the state of Washington because they never come to the state of Washington. And you can't serve the people who are just there soliciting orders because they're not the kind of people we can serve. We want to say we can still get jurisdiction over them. It goes up to the Supreme Court of the United States. And the Supreme Court said in that case, famously, if a person is not present in the state, a state can still assert jurisdiction over them if the person has such minimum contacts as to not offend traditional notions of fair play and substantial justice. That's the language pretty close to exact words out of International Shoe. If he be not present, they say if he be not, very old-fashioned English. If he be not present, state can assert jurisdiction if the person has such minimum contacts as to not offend traditional notions of fair play and substantial justice. That's 1944-45 International Shoe. And now, for the last 50, 60 years after International Shoe, the Supreme Court and lower courts have been working out what it means to have for a defendant to have such minimum contacts as to not offend traditional notions of fair play and substantial justice. And so I would highly imagine that you read a whole bunch of cases in your first year of law school, and they were very confusing to you in your first year of law school, because you were in your first year of law school when you know almost nothing, right? And now if you read them, I think they would probably begin to make a lot more sense to you, but you don't have time to read them in detail at this point. But you just need to say, what are they doing in that whole series of cases? They're trying to decide who has such what minimum contacts are going to be sufficient to allow a state to assert jurisdiction over a person. One famous case, Hansen against Denkla, involved a trust company. And the trust company was located in the state of Delaware, and it held a trust on for the benefit of someone who put the money in the trust who lived in Pennsylvania. And if you ever look at a map, Delaware is almost like a little pimple on the state of Pennsylvania. It's so tiny. It's just down that little corner of Pennsylvania. There's an extra little pimple. That's all it is. So tiny. And so a Delaware corporation was almost certainly going to be doing business with people in Pennsylvania because the boundary was like 5 feet away. So they kept doing business with this woman in Pennsylvania, handling her trust problems, and she did something that sometimes people up north do. She moved to Florida. And she moved to Florida, and then there came to be a dispute about her estate or about her trust in the state of Florida. And so this dispute in the state of Florida, they served the trust company in Delaware and say, you have to come down here to Florida to defend. They did not start the suit. Somebody else started the suit against them down here and said, hey, you have to come down to Florida to defend. And the defendant said, wait a second, we did not have such minimum contacts with the state of Florida as to justify this. And the plaintiff said, of course you did, because you were the trustee of a trust with a lot of money in it, and you sent mail back and forth to this woman in Florida, back and forth. You knew she was in Florida, and you kept taking care of her trust even though she was in Florida. That's minimum contacts. And the Supreme Court of the United States said no. And the reason no is they said the contacts have to be ones that were initiated by the defendant. Defendant has to have initiated contact with the state in order for those contacts to be ones that count. And so this trustee did not initiate any contacts with Florida. It's rather that the beneficiary or the settlor of the trust moved to Florida, and all they did after that was keep sending her checks and stuff, but they did not initiate the relationship with someone in Florida. Therefore, Florida could not require the trust company to come and defend in Florida, and if they wanted to litigate with the trust company, they'd have to go back to Delaware. That's one limitation. If the defendant did not do an act that purposely availed itself to the benefit of that other state's law, the state can't call them in. Well, there are a series of cases. Another one that's well known and important is the VW case. In the VW case, some people in New York bought a car called a VW automobile. And when they bought it, they were intending to move to Arizona. And I think they even told the people from whom they bought the car, hey, we need a car and we're going to be moving to Arizona. And I was, no, can I get service along the way? Is this a car that can only be serviced in a few? Oh no, we've got a nationwide series of dealers, all of whom will service, all of whom will recognize the warranties and so forth. So now they bought the car, which was manufactured in Germany by VW Corporation, sold to a national distributor, and then sold to the local company. I think the local company was called International VW, whatever, but sold to the local retailer who sold it to the consumers, the Woodsons. The Woodsons got in their car and they drove toward Arizona. They didn't make it. In Oklahoma, they got into a major accident in which several of them were seriously injured, and now they want to sue, and all the evidence is in Oklahoma. And they are in Oklahoma. So they bring the suit in Oklahoma because the Woodsons who were injured are in Oklahoma, and the evidence is in Oklahoma, and people who might have been injured by the car are in Oklahoma. So if there's a claim that this car was defective and that the retailer, as well as everybody else in the chain, should be liable, then shouldn't they come to Oklahoma, which is the most convenient place to present this case? The answer, no. Because even though VW, the retailer, knew when they sold the car, the cars can be taken to other states. They had no particular reason to foresee being hailed into court in Oklahoma, such is the wisdom of the Supreme Court of the United States. What about the fact that you wouldn't buy a car in New York if you couldn't get it serviced in Oklahoma? VW can't sell cars to people in one state that they're not ready to service all over the United States. And they all have these supply chain, or these chains of dealers, all of whom will service everything. They ignored that practicality and said the retailer in New York could not foresee being hailed into court in Oklahoma. Now, the manufacturer could, so we can have the manufacturer, the bigger people distributing for the whole country, but not that poor little retailer. Which means if I'm injured by this retail product, I've got to go back to New York, but all the evidence is in Oklahoma. It seems like a very inconvenient thing. When the evidence is Oklahoma, I have to go back to New York. But that's the wisdom of the Supremes. Then we have another case involving Florida, the Burger King case. You know, Florida is filled with wonderful universities. There's the University of Florida, there's Florida State, there's Coastal, and there's Burger King University. You know, there's a Burger King University where people come to do what? To learn how to flip hamburgers, right? All these franchise companies have their own, what they call university, kind of like Trump University. They teach you how to flip a hamburger or how to run their little franchise business or whatever.
Yeah,
So, what?
I said McDonald's has one too.
Subway has one. I've seen it because the Subway's in my hometown, right? Yep, they all have
McDonald's
these.
is in mine.
Huh?
No, McDonald's is in my Oak Park, Illinois.
Oh, okay. So yeah, so university, but you know, the courses are not exactly university level courses, right? Anyway, so the franchisees who are business guys with, you know, a little bit of money, but they're in Michigan, I believe is where they were. They bought a franchise from a Florida corporation. Now they have a dispute with the Florida corporation. And they say, wait a second, we should not be subject to suit in Florida over our dispute because we're little guys and Florida's far away and it's going to be very expensive for us to go defend in Florida. Make Burger King come and have this litigation in Michigan. And the court said, no, it's not that Burger King couldn't sue in Michigan. They don't have to. They sued you in Florida, and Florida has jurisdiction over you because you purposefully availed yourselves of the benefit of Florida law. You chose to enter into a franchise relationship with a Florida corporation, and you even went to their university for 2 weeks. So therefore, Florida can take jurisdiction over you. It does not offend traditional notions of fair play and substantial justice. So this is an area where I'm going to say there are about 6 or 8 cases in what is or is not within that minimum context so as not to offend traditional notions of fair play and substantial justice that are case squibs in your outline. I want you to read every one of those and expect you will have at least one of those will appear somewhere on your exam and you want to know what they are, okay? There are a couple of others. The one that I guess the only other one I'm going to mention right now is one that used to be, it was a subject that was on my final exam in civil procedure for 10 years in a row, and I'd always tell the students on the first day that this was going to be on the exam. A person goes into a state for one moment and is sued and served with process on account of something that has nothing to do with why he's in the state. And I always had him lured into the state by something like the potential defendant is a butterfly collector, and the plaintiff sends him a notice that this rare butterfly is to be found in this location in the state, and he comes in and he goes to capture the butterfly. Instead, he is netted with process. Or he's into competitive tennis, and so the plaintiff sets up a tennis match and invites him into the tennis match, and he is served with process. The guy was always lured into the state, and the suit always had nothing to do with why he was in the state. Is there personal jurisdiction? Well, in a fairly well-known case, the Burnham case, the Supreme Court finally got around to deciding whether just being present in the state was enough for jurisdiction if you're served, even if you don't have any contacts, or do we do a minimum contacts analysis and ask whether there are enough contacts? Justice Brennan said we need to have enough contacts. Justice Scalia, who had one more vote than Brennan had on this, said you knew it was a Scalia opinion because the very first page of his opinion cited a case that was decided in 1482. And you saw this in 1482. That was well before the Constitution. That was well before the United States came into existence. That was before Columbus sailed the ocean blue. Why are we citing a case from 1482, Justice Scalia? To show that this tradition is deeply rooted in history. Deeply rooted in history. If they catch you in the state and they serve you with process, that's enough and they can do it. And nothing that has happened since changes anything. So as long as you are served while present in the state can take jurisdiction over you on things that have nothing to do with why you're present in the state and require you to defend in that state. And we don't do a minimum contacts analysis, says the court in Burnham. Now, just add one other thing for the fact you're all going to be practicing law within a year, I hope, right? And you have a client who comes into your office and he says, or she says, I'm a father, I'm a mother. My kids are out there with my spouse in Seattle. They moved out there. And I miss them and I want to see them, but potential litigation. What should I do? Don't visit them. Don't visit them. Because if you go, as Mr. Burnham did in the Burnham case, to visit your kids for an hour, you now all of a sudden can be sued in the state of California. And if you haven't noticed, California is thousands of miles away and expensive to get back and forth to. And you never had anything to do with California except your spouse, male or female, chose to move to California. You didn't choose to move to California, they couldn't sue you in California otherwise. But if you go to visit your kids for an hour, you are subject to personal jurisdiction, and they can enter a judgment taking away your money and your property and everything else. That's what Burnham stands for. Scalia just didn't even pay any attention to the practical implications of his decision. But that's the law. Be careful about advising clients in this situation. Okay. Visit your kids not in California. Or whatever. At least be aware that that's the risk that Burnham creates. So, you have a...
Yeah, that's what we're talking about,
Yeah.
It's crazy.
And in the whole case, nobody discussed the practical implications
I
of
don't
the
think
case.
people really realize
Huh?
that. I said, I don't think people don't really realize that, like how easy it is for states just to...
Oh, I mean, it's just so obvious and just didn't get discussed in the case. It blew my mind. It just didn't get discussed. The impact on people's ability to visit their children in a far-off jurisdiction.
And that happens all the time.
Yeah.
People go...
And Burnham has now said, hey, discourages people from visiting their kids. Anyway, but the first point is one of the major topics of jurisdiction procedure is when can a state assert jurisdiction or power over the person of a defendant? Well, they can do it if any of the traditional bases of jurisdiction exist. That is, we serve the person in the state now that we don't even need minimum contacts for that, Burnham says. Or if the person is domiciled in the state or has an agent or consents or has such minimum contacts as to not offend traditional notions of fair play and substantial justice, then it's constitutional for a state to assert jurisdiction. But just because it's constitutional does not mean the state has actually asserted that jurisdiction. We need a statute, because even though the state can assert jurisdiction, we need some state statute, and there will be state statutes that say you can serve people while present in the state, you can serve people who are domiciled in the state, but the ones that you're more likely to see tested on are a long-arm statute, as it is so called, a statute that says, we, the state of whatever, assert jurisdiction over anybody in another state who does a tortious act that causes tortious injury in the state, or anyone who outside the state breaches a contract that has direct impact in the state. Whatever the definitions are in the long-arm statute is potentially there for you to have to apply, right? Did the person actually fall within the confines of the long-arm statute? So read the materials on the long-arm statute, because we need a long-arm statute under which the state says we're going to take jurisdiction, and then it needs to be constitutional in addition under the series of cases from Pennoyer to International showing up through Burnham, okay? That's how we get personal jurisdiction over a defendant. There are minor topics, and are really minor. I want you to read them, but I would not expect questions on them with any regularity, called jurisdiction in rem and jurisdiction quasi in rem. A state can assert jurisdiction not over a person, but over property. And the most typical case of that is going to be a quiet title action in relationship to a piece of real estate here in Florida. But there are people who might have claims to that property in 5 other states. Florida gets jurisdiction by attaching the property itself and then sending notice to all potential claimants, and can determine who owns the piece of land because the piece of land is in Florida, as long as they give notice to everybody who might have possible claims. That's in rem jurisdiction. There is also quasi in rem jurisdiction. I'm just going to read in the outline on it. It's possible for testing, not that heavily tested, but that's personal jurisdiction, jurisdiction over the person. In addition to needing jurisdiction over the person for a state to take power, you also need, believe it or not, this is going to sound familiar from constitutional law, you need for the state to give notice and an opportunity to be heard to the defendant. So it's not enough to say we have the power to require this defendant to appear. You have to actually give them notice that you're asserting that power and an opportunity to be heard under the Due Process Clause. Did we give them notice and opportunity to be heard? Well, if we serve them with process in hand, here's service of process, that's certainly going to be notice. But what if we publish in a newspaper? What if we mail service? What's going to be adequate notice? You want to read in your outline. The main case that you'll see discussed there is the Mullane case. It's an old case. Talk about what notice is adequate to give somebody notice, or what is adequate to give somebody notice. Notice and an opportunity to be heard before we take their property. Now, that's state court personal jurisdiction. What if I'm in federal court? I said state court personal jurisdiction is limited by the boundaries of the state, serving someone in the state or serving someone who has sufficient contacts with the state so as not to offend traditional notions of fair play and substantial justice. That's for a state court. Now I go to a federal court. Does a federal court have to use those restrictions, or can federal court take jurisdiction over anybody who has minimum contacts with the whole United States of America? The geographic limits of federal jurisdiction could be the whole United States. It's not, generally. The federal courts, because Congress says so, have jurisdiction over the defendant using the exact same rules 99% of the time that we use for state courts. So the federal court in Florida can take jurisdiction over people who are subject to personal jurisdiction in Florida under Florida long-arm statutes and under the Due Process Clause, right? The minimum contact standard derives from the Due Process Clause. So the Florida federal courts are 99% of the time limited to people in Florida or have minimum contacts with Florida, with a couple of exceptions that are worth knowing, and you'll see them in your outline. There are times when if a case is in a federal court, the court has jurisdiction up to 100 miles in every direction to bring in third-party defendants and stuff like that. So read the 100-mile rule. But that's personal jurisdiction in the federal court. Basically the same as in the state court. We're done with that kind of power, personal power. I'm now going to shift over to power over the subject matter of the case. And how much time you spent on this in your first year civil procedure course, you can tell me later. It varies with the professor. But going to federal court, why would federal courts be different? Why would it be so important? Because federal courts are created by the thing we were just talking about last week, the Constitution, right? Federal courts only exist because we have a Constitution. They get their power from the Constitution, and the Constitution says the judicial power of the United States shall extend to, and then it lists certain kinds of cases. So whether a federal court has subject matter jurisdiction is a matter of constitutional law, in part. And the most important things in the Constitution in terms of the power of federal courts are federal courts have power to hear cases arising under this Constitution, statutes, and treaties. And federal courts have power to hear cases between citizens of different states or between citizens and aliens. So diversity jurisdiction and alienage jurisdiction. Those are the two really important ones that are tested a lot. Those are called subject matter jurisdiction. People often find this a little confusing because it's got something to do with who the people are, right? Diversity of citizenship. Yeah, but that's not personal jurisdiction. That's a kind of case that can be heard in federal court. Case between people who are citizens of different states or between a citizen and an alien is a kind of case. It's the subject matter jurisdiction of the federal court, in addition to which the federal court's still going to need personal jurisdiction over any defendant. But that's what we were discussing earlier. Now, there is the Constitution, and there are statutes. And you might say, what's the relationship between them? I want you to understand this because it'll make other things a little bit easier. I probably have not bored you with my story about a guy who became famous as the sleeping senator from Hawaii. From Hawaii or California. Anyway, his name was S.I. Hayakawa. And he wrote a book that I read in my very first year of college. It's the only book I remember from my first year of college. It was called Language in Thought and Action. And the reason I remember it is because we just all giggled over his basic proposition, which was Cal 1 is not Cal 2. It was a book about language and the use of language, and the basic proposition is Cal 1 is not Cal 2, which means that we use a word and we may use it in very different senses. It sounds like it's the same word, but it means different things in different contexts, right? If I use the word cow referring to that animal that's out in my backyard, which I go out and milk hey, I've got a very nice cow out in my backyard. Or I'd say, he's a real cow, by which I mean he's someone without a lot of energy or something like that, right? Cow can mean many different things depending on the context in which we're using the word cow. So cow doesn't just have one meaning, it has a meaning in the context in which it's used. Okay, Rich, what are you talking about? Okay, this is what we need. The Constitution says that the judicial power shall extend to all cases arising under this Constitution, statutes, and treaties. Then we have a statute that's now 28 U.S.C. Section 1331, and that statute says what? The judicial power, the district court shall have power over cases arising under this Constitution, statutes, and treaties. You might say, well, it's the same language, so therefore it means the same thing. No. Cow 1 is not Cow 2. The language, the very language that's used in the Constitution that gets then incorporated and used identical language in the statutes gets interpreted to mean different things. And understand that. That's how, because, see, you're about to be lawyers, and so you have to be able to explain to people how crazy lawyers are, right? Cow 1 does not mean Cow 2. Have you ever heard of a group called the American Bar Association? Yep. I don't know what the rules are these days because I don't pay much attention, but at least in my much earlier days in law teaching, they had a rule that said a student who is registered as a full-time student cannot work for compensation in excess of 15 hours a week. Sounds a little paternalistic, right? You can't work more than 15 hours a week if you're a full-time student, so that means starve to death if you have to work 20. You can't do it, and the schools were supposed to enforce it. And so they went around to schools, and they found that people were working in excess of 15 hours a week while being full-time students, at which point they should have said, this school, if you don't fix this, you're going to lose your accreditation or something, but instead they interpreted 15 to mean 20. What? Is it? Yeah, the rule says they can't work more than 15 hours a week for compensation. We interpret 15 to mean 20. Only a lawyer could do that. I mean, what do you mean 15 means 20? I know what 15 means. It means 10 plus 5. It doesn't mean 10 plus 5 plus 5, but they interpreted 15 to mean 20. That's lawyerly thinking. We interpret the language, okay? So what I'm saying is, be aware, as a starting point, that the scope of the jurisdiction of federal courts in the Constitution and in the statutes that use identical language is not necessarily the same. The Constitution is the broadest possible interpretation of the power, and the statutes have always been interpreted narrower. And we'll see this, not right now, but we'll see it coming up. So, diversity jurisdiction, federal question jurisdiction looks largely the same between a federal court, between the Constitution and statutes, except for this. When do we have federal subject matter jurisdiction over a federal question? Only when the federal question, does anybody know, appears on the face of the well-pleaded complaint. Does that sound familiar? Ring a bell? No. Okay. Well, did you study this in civil procedure? That you remember?
Say it one more time.
Subject matter jurisdiction, federal subject matter jurisdiction exists only when the federal question is on the face of the well-pleaded complaint. Yeah. Okay. The case is Louisville and Nashville Railroad versus Motley. The Motleys, I'll tell you the facts briefly. The Motleys had settled a lawsuit with the railroad at some time in the past by getting a free pass to have free train rides for the rest of their lives. Free for the rest of their lives. And then Congress passed a statute for whatever reason, who knows why, and says nobody can have free passes on interstate trains. So when the Motleys said, renew our pass for next year, the railroad said no. The Motleys sued and said, we're entitled to the free pass, and the only reason you're denying our free pass is this federal statute. They brought their suit in federal court. They got a decision. Federal court went up to the Court of Appeals, no problem. Went up to the Supreme Court of the United States. On the merits of whether the statute prevented them from getting the free pass, the court didn't get to that issue. They said there's no jurisdiction. They said, even though the federal trial court acted as if there was jurisdiction, even though everybody below thought there was jurisdiction, even though everybody until it got here thought there was jurisdiction, even though the lawyers didn't even argue there's no jurisdiction, we have a duty not to hear cases over which there is no federal jurisdiction. And that federal trial court had no jurisdiction because the Motleys' complaint did not raise a federal question. Only the railroad's defense did. And you can't anticipate a defense and get jurisdiction that way. Your federal question must appear on the face of the well-pleaded complaint. Otherwise, that federal district court has no jurisdiction. Dismissed. Now, you're the Motley's attorney. You bring the case now in state court. You bring the case in state court, and the state court, let us imagine, holds that the federal statute is unconstitutional for trying to take away the Motley's right. And so you say the federal statute cannot be applied. The railroad appeals to the Supreme Court of the United States or petitions for cert. Can the Supreme Court hear the case?
Yes.
Yeah. But wait a second. The federal question didn't appear on the face of the well-pleaded complaint. So how can the Supreme Court take jurisdiction? Because whether the case arises under the Constitution for purposes of getting to the Supreme Court does not turn on the well-pleaded complaint rule. That's only for the trial courts. But whether we, the Supreme Court, can take jurisdiction depends on whether the case actually turned on an issue of federal law, in which case we can. So the meaning of a case arising under the Constitution, statutes, and treaties in the Constitution, and therefore supporting Supreme Court jurisdiction over an appeal, is broader than the meaning of arise under the Constitution, statutes, and treaties for purposes of 1331, even though the language is exactly the same. The same thing is true for diversity jurisdiction in a somewhat different way. The Constitution says that the federal courts may have jurisdiction over cases in diversity, and then Congress chose to give that jurisdiction to the federal trial courts. Federal trial courts have original jurisdiction over, and they say cases between citizens of different states where the amount in controversy exceeds $75,000. The Constitution doesn't say anything about any amount in controversy. So now how do we interpret the statute? The statute says we're not giving all of the jurisdiction you could have had under the Constitution. It's only if, number one, they interpret the statute to require complete diversity. There can't be any overlap between any plaintiff and any defendant. We have 10 plaintiffs and 10 defendants and 10 states on this side and 10 different states on this side, but there's one person who overlaps. We don't have complete diversity. You can't have any plaintiff sharing state citizenship with any defendant. If you do, you don't have diversity. They don't interpret the Constitution as requiring complete diversity. They only interpret the statute 1332 as requiring that complete diversity. They don't interpret the Constitution as requiring $75,000 or over $75,000. That is a statutory matter. So again, the Constitution allows for broader interpretation of the jurisdiction of the federal courts, what's possible, than what Congress chose to give in 1332. So be aware of that. But you're mostly going to be looking at the statutes. Does this case arise under the United States Constitution, statutes, or treaties? Or two, is it a case between citizens of different states, complete diversity, with in excess of $75,000 in controversy? You will then find in your outline, or if you want to be really bored with it, you could read the federal rules on this. You will find, or actually the statutes on this, all sorts of variations, like, of what state is a person a citizen? Well, a natural person, that's like one of us with hearts and souls and lungs, right, is a citizen of the state in which he or she is domiciled at the time the suit is filed. Not at the time the cause of action arose, and not at the time of the trial, but the relevant time for citizenship or domicile is the time the suit's filed. So if the plaintiff has changed, it doesn't matter. It's still wherever the plaintiff is a citizen at the time the suit is filed, wherever the defendant is a citizen at the time the suit is filed. And if they change afterwards, it does not eliminate diversity. Okay? That's what matters. And of what state is a person a citizen? State in which they reside with intent to remain indefinitely. Reside, intent to remain indefinitely. If I've decided I'm going to move to Arizona, but I'm on my way in my car, but I've only gotten to Oklahoma, and I get into an accident, and I never get to Arizona. I haven't become a citizen of Arizona. I never got there. You have physical presence plus intent to remain indefinitely to be domiciled. But that's relatively easy, right, at the time of the lawsuit. What about corporations? What about unions? What about partnerships? What about people who have representatives, like a beneficiary of a trust? What about an insane person who has a protector of some kind, a legal protector? Read all of those rules. I'm not going to go through them all. Read all of them because you'll probably have one of those appearing on the test. Of what state is a person a citizen? So we have jurisdiction over the person based on, jurisdiction subject matter based on federal question, jurisdiction over the subject matter based on diversity. Those are the two big kinds of federal subject matter jurisdiction. Very little else will ever be tested, but you read about the rest. But there are three other big topics under federal subject matter jurisdiction. Remember, we're selecting the court right now. We haven't gotten to actually start a lawsuit. But three other big topics. Do we have original jurisdiction is the first one. But what if the case has been brought in a state court? May it be removed to a federal court? So a case that's begun in a state court might get removed to a federal court, and that's probably going to be one of your 200 questions on the bar next July. So you want to read the stuff about removal. A case can only be removed if it could originally have been brought in a federal court. And removed to that federal court, that is the federal court for the area in which the state court sits. So you can't remove from Jacksonville, Florida state court to a Georgia federal court. It would only be to the federal court for this area of Florida, not to another federal court elsewhere. And you can only remove it, as I said, if it originally could have been brought in a federal court. And you can only remove if all of the defendants are agreeable to removal. So if there are three defendants and two want to remove, but the third one doesn't, you can't remove unless all three agree. With exceptions, of course. There's an exception, but I'm not going to go into the exception right now. And there's a time limit on removal. You've got to remove within 30 days of the time the case became removable. The case might have been brought, it was not removable, but then something happened later to make it removable. From whenever it became a removable case, you have 30 days to initiate the removal. And if you don't, you can't remove it anymore. And there's another rule about in a diversity case, you also can't remove more than 1 year after the suit was filed. So suppose a year later, a year and a day later, one of the parties is dismissed, so now all of a sudden we have diversity, it's now too late to remove. But the 30-day rule is more important than the 1-day rule, and the dates are not the biggest thing. So we have removal jurisdiction. We can remove from a state court to a federal court where the suit might originally have been brought if all defendants are agreeable. But in a diversity case, a defendant can't remove to his own state's federal court, because why would he be expecting to be discriminated against? So you have all these little rules about removal. Learn them. You will have one question on them. In addition to, what's the matter?
She's
Well-
laughing because you said there's one question.
Yeah, one question, right?
For all of that.
Yeah. But at least I want you to feel pretty sure you're gonna you want to know it, okay? And you don't need to know much deeper than just a little deeper than what I just said, okay? And we also have a thing called supplemental jurisdiction. Now, there is the tricky one and the one that is really highly likely to be tested, supplemental jurisdiction. Until the 1990s, we did not have a thing called supplemental jurisdiction. What we had was two doctrines called ancillary and pendant jurisdiction that were developed by the courts. They were evolved as a matter of case law. And lo and behold, the Congress decided to put them all together and make a statute. So supplemental jurisdiction, it's 28 U.S.C. section 1367. And I'm not good at remembering numbers. That one's stuck with me. Okay, there it is. Was adopted. The idea was to put together these old-fashioned doctrines of ancillary and supplemental jurisdiction. And what are they all about? At the most simple, what they're about is judicial efficiency. Why should we have 6 separate suits about the same thing? Why shouldn't we consolidate them together if we can, right? So when would a federal court ever get supplemental jurisdiction? When a case is brought in federal court that belongs in federal court, there's federal subject matter jurisdiction, but there are other disputes that are so intimately related to that federal case that's already in federal court that it makes sense to have them heard as part of the same case. The language that was used in the famous Gibbs case by Justice Brennan was, we can take jurisdiction over things that arise out of a common nucleus of operative fact. Common nucleus of operative fact. The more modern term for it is the same transaction or occurrence, which language you've heard, right? Same transaction or occurrence, common nucleus of operative fact. In other words, remember we had common law last week? what do we mean by a case or controversy within the meaning of the Constitution? Article 3 says the judicial power shall extend to cases. And so the question that the court has had, and this has been going on for 200 years, it's not a recent innovation, the scope of a case may be broader than that over which there is federal jurisdiction. There's federal jurisdiction because it arises under a federal question, but there may be related matters that arise out of that same transaction that are state tort law or state, they don't have to do with federal law. And the Supreme Court from very early on said, if these other disputes are part of the same case or controversy, once the federal court has established jurisdiction over the basic claim, these others can come in as ancillary to, or in modern terms, as supplemental. So if you read carefully, and it'll be in your Barbie outline, 1367 says, federal court can take jurisdiction over other matters that arise out of the same transaction or occurrence or series of transactions as the original lawsuit, even though they don't have an independent basis of jurisdiction over them. Except, the favorite word in the law, the word except. They can do it, except sometimes they can't. So, if we have a case in a federal court, right, federal court, they can take jurisdiction over other things arising out of that same transaction or occurrence, a STUC, same transaction or occurrence. They can take jurisdiction over related matters arising out of that same transaction or occurrence, except in diversity, it's limited. In diversity, they cannot take no supplemental jurisdiction in diversity over claims by the plaintiff against various people. Now that's the structure. Okay, so here's our plaintiff, here's our defendant, and imagine we're in diversity. Oh God, I'm going to have to complicate things. I hate doing that right at this point. You know the song, Que Sera, Sera. Wait, whatever must be, must be. Here's the problem. I'm right now talking to you only about jurisdiction, right? But you can't understand this next point without getting to joinder, which is further on. Yeah, you're making a face at me, right? Okay, rules of joinder. Because the federal rules of civil procedure have rules about joinder of parties and joinder of claims. And sad to say, the federal rules say these are things you can join or you must join, but we're not giving you jurisdiction over them. So if the federal rules say you may join this, you must join this, you still need to get jurisdiction in addition to having a rule that allows joinder. Let me give you an example, and as we go along, hopefully it's going to get clearer. Plaintiff against defendant for a car accident, and defendant has a claim back against the plaintiff from the very same car accident, and the plaintiff's claim against the defendant is for $76,000, excess of $75,000. Defendant's claim back against the plaintiff is for $10,000. Well, and this is, plaintiff is from Connecticut and defendant's from Florida, right? Citizen from Florida. So we have Connecticut against Florida, diversity, $76,000, plenty of controversy. But now the defendant from Florida has a compulsory counterclaim for $10,000 from that same car accident. But where's the jurisdiction over the person? The rules of joinder say that you must join this. I'll get into that later. You must join it. But there's not sufficient in controversy, only $10,000. It's all right to get supplemental jurisdiction. Okay? That's defendant back against the plaintiff. Now, what if it's plaintiff against defendant for $77,000, and defendant brings in under Rule 14, I'm going to pray that you have some memory that there is a thing called Rule 14. How many of you remember that there is a thing called Rule 14? How many of you took civil procedure in your first year? Okay. Okay. I know, yes, I'm just kidding. But Rule 14 says that a party who is a defendant on a claim can bring in a third party, someone who's not a party to the case, and say, hey, D3, you will be liable to me if I am liable to the plaintiff. A very typical situation is, see how procedure ties back to our substantive law, in torts. Plaintiff brings a suit against defendant retailer on account of product liability. But defendant retailer says, well, we bought that product, and if we're found to be liable for a defective product, then we have a claim against the manufacturer. Manufacturer will be liable to us if we're liable to the plaintiff, right? So that's all we mean. 14A, we're bringing in someone who is not a party to the original case, and we're saying, if we're liable to the plaintiff, you're liable to us. Now, the plaintiff is from Connecticut, citizen of Connecticut. The original defendant is a citizen of Florida. And let us imagine D3 is a citizen of Connecticut and of Florida. Okay? Guess what? There is no diversity between this person and this person because it's Florida against Florida. Doesn't matter because we get supplemental jurisdiction. Let's imagine now that this person is a party to the case. He has some claim back against the plaintiff for something. Well, the rule says he can bring any claims he has against the plaintiff arising out of that same transaction. And supplemental jurisdiction says he has supplemental jurisdiction over that. But as soon as the original plaintiff amends his complaint, say me against the third-party defendant, now it's Connecticut against Connecticut, and that's the limitation, no supplemental jurisdiction. I will go over this 3 or 4 or 5 times between now and the bar until it comes into making sense. But basically, you do not get no supplemental jurisdiction in diversity cases over claims by plaintiff against people brought in under Rule 14, 19, and a couple of others, right? Or 24, right? So plaintiff cannot get supplemental jurisdiction against people who became parties later in the case under Rule 14 or under Rule 19 or under Rule 24. No supplemental, only if the plaintiff has original jurisdiction. If there was diversity, that'd be fine. If there was a federal question, that'd be fine. But no supplemental jurisdiction for if we're in a diversity case and it's plaintiff against any of these people. Does that make a glimmer of sense? You say, well, why would we say you can get supplemental jurisdiction over everything arising out of that same transaction or occurrence with this limited set of exceptions? And I'll try to explain to you why, even though I don't think it makes altogether good sense. Because if the plaintiff can get supplemental jurisdiction over people added to the case later on in diversity, then he couldn't have originally brought the case against those people because that would have been no complete diversity. Now we're allowing the plaintiff's attorney to manipulate things. Well, I'm just going to sue the one person because I'll know they'll bring these other people in, and we don't want to let the plaintiff's attorney manipulate things to accomplish this goal. So we're going to say no supplemental jurisdiction in a diversity case in this limited set of circumstances. Otherwise, we do, right? We have, if it's a federal question case, there is going to be supplemental jurisdiction if it arises out of the same transaction or occurrence. Anything added to the case, D against D3, P against D3, D3 back against P, everything as long as the basis for being in federal court is federal question. But if the basis of being in federal court was diversity, we put limits on who the original plaintiff can get supplemental jurisdiction over. Okay? We'll see enough examples of it. Hopefully it'll make sense as we go. But supplemental jurisdiction is a tricky enough thing that I think you can expect a fair prospect of at least 1 or 2 pretty tricky questions involving it. That would be my expectation. But they've released so few questions, it's really impossible to be sure. So now, we have the Constitution and statutes for jurisdiction. Then you just read what it says in the outline. It's not terribly important, but read what it says in the outline. More important is the famous case of Erie Railroad. We're still at the point where you're just selecting who your decision maker is going to be, right? We haven't started the lawsuit yet. We're deciding where to bring the suit, in what court. And I maybe should have tied in, our present rules, federal rules of civil procedure, did not exist before the 1930s. They were adopted in the 1930s by the Supreme Court, by the Congress, to replace an old system of procedure which was very confusing, in which there would be different procedures in different states. There was no uniform rule of procedure in federal courts. The federal courts in Pennsylvania would use Pennsylvania procedure. The federal courts in California would use California procedure. There was no common set of procedure for all the federal courts. So the Federal Rules Enabling Act, that was the statute, told the Supreme Court they could create a set of rules of procedure for all the federal courts. And they did, called the Federal Rules of Civil Procedure that apply in all the federal courts. And another thing happened at around the same time. In the 1930s, up until the 1930s, from way back in the early parts of the 19th century, 1820, something like that was the first case, if you brought a suit in a federal court for diversity purposes, right? I'm a citizen of Florida, you're a citizen of Georgia, and I sue you for torts. The federal court would, in diversity, apply federal common law of torts, federal common law of contracts. They would make up a federal common law. They would not rely on what the law was of the particular state in which they sat. And there were thousands and thousands of these cases saying what federal common law was of duties of landowners to people coming onto the land, or pre-existing duty rule. Thousands of cases. In the 1930s, in the Erie case, remember that name, Erie? Erie Railroad against Tompkins. In that case, I don't think any case has ever overruled so many cases at one time. Case goes to the Supreme Court of the United States, and it was a relatively simple torts case. And the question was whether the federal court was supposed to apply the federal law as to whether someone was a trespasser, a known trespasser, or unknown, all those duty rules and torts. Gets up to the Supreme Court of the United States, and they said, it's all been a mistake. For 100 years, we and all the lower federal courts have made a terrible mistake because we have been creating and applying in these diversity cases federal common law of torts and contracts. And that they said, but there's no authorization to do so. The Constitution says we have jurisdiction over cases between citizens of different states. It doesn't say we can make up the law for them. It just says we can provide a neutral forum for them. And Congress, when they passed the statute saying, you have jurisdiction over diversity, didn't say, and by the way, create a federal common law. Maybe Congress could have authorized us to do that, but Congress never said make a federal common law. And so the Supreme Court in the Erie case said, there is no general federal common law. We can't just make it up. It doesn't exist. And we're not authorized to create it. So from now on, those 10,000 cases are no longer of any importance. And number two, the federal court in diversity case, only in diversity case, not in any other kind, must apply state law of the state in which it is sitting. So the federal court in Florida, in a diversity case, must apply the state law of Florida. General rule, almost always. But the state law of Florida sometimes will include Florida choice of law rule. Florida might sometimes apply the law of North Carolina. So that's the one extra little complication. If it's a suit involving things that occurred outside the state of Florida, Florida might, under Florida law, might say we would apply North Carolina law. Then the federal court will apply Florida law, which would be North Carolina law. You don't need to know any more than that's the rule, that they would apply whatever law the state court would apply, which would be North Carolina law. That's the beginning of things with Erie. But as you know by now, it never is as easy as all that, right? What are we supposed to apply state law to? What issues? And Erie wasn't altogether clear about that, but it came to be announced that what we meant in Erie was the federal court in diversity must apply state law of the state in which it's sitting to substantive issues, but not to procedural issues. Because otherwise, what would happen to those federal rules of civil procedure? Hey, do we have to apply the state rules of procedure? No. You only have to apply state law of substance, not state law of procedure. Now, what the heck is state law of procedure and what is state law of substance? Is that an easy one? Well, there might be easy cases, but what is procedure and what is substance? Well, roughly speaking, very roughly speaking, the court established the notion that anything that is actually explicitly covered by one of the federal rules of civil procedure is procedural. And therefore, we will apply our own federal rules of civil procedure if they're in conflict with state law of procedure. If there's a real conflict, we'll apply our own law of procedure from the federal rules of civil procedure. But there are lots of things that aren't a matter of the federal rules of civil procedure, like do we use a jury trial or do we not use a jury trial? The answer is we use a jury trial. We use the federal standard for whether to use a jury trial because that's a matter of federal law, and states can't say, well, this is something we would not give to a jury. We will give it to a jury if a federal court would give it to a jury. We won't use state law. So read all of the variations on the Erie case, right? And I'm saying read all the variations. Probably not going to have more than one question, so don't get too wound up on it, right? But one question on Erie, choice of law. And now we have chosen our court. We've found a court that has power to require the defendant to appear, personal jurisdiction. We have found a court or courts that have power to hear the kind of subject matter, federal subject matter or whatever, and we've decided whether we're going to apply federal or state law under Erie. And now we go to the next step. See, the first step in this timeline is picking the court that we want to decide our case. Once we've picked the court that we want to decide our case, we actually have to get a case going. Time to start our case. Well, what do we need to do to start our case? We need service of process. We need that set of procedures by which we assert the power. Subpoena is served, complaint is served on the defendant, and they have to respond, right? And we have rules of pleadings, which, as I said, are very simple in the federal rules. Complaint, answer, and occasionally something else. But note, the federal rules do provide that some things, rare things, must be specially pleaded or they're waived. So pay attention to those. That's one of your questions of your 200 on the bar is going to be what things must be specially pled. Now we come to that subject that I started to get to, joinder. And joinder is either a lot of fun or a lot of confusion, depending on how you want to look at it, right? We have a bunch of terminology to learn with joinder, but I'm just going to go through some of the most basic parts of it, and then you read through the outline and you'll see, and from what I observed last semester, the terminology got confusing to people. So we'll work on that. Plaintiff has sued defendant. What can the defendant do in response to the plaintiff? That's Rule 13. Rule 13 says a party defending must bring as a counterclaim, or may bring as a counterclaim, they call it, counterclaim, or may bring as a counterclaim. This is Rule 13A and 13B. What must you bring as a counterclaim? Any claim the defendant has against the plaintiff that arises out of the, guess what, same transaction or occurrence. If the plaintiff is suing the defendant for injury in a car accident that occurred on May 13th, 2014 at the intersection of X Street and Y Street, if the defendant has a claim arising out of that same automobile accident, that's a compulsory counterclaim, and he must bring it as part of the suit. Doesn't have a choice, must bring it right now. But if the defendant has any other claims that do not arise out of that same transaction, then he may bring them as part of the same suit. Okay, we have this dispute about the automobile accident, but besides which, defendant has a totally separate breach of contract action against the plaintiff. He may join that. But if it's compulsory counterclaim, you get supplemental jurisdiction. If it is only what's called a permissive counterclaim, you don't get supplemental jurisdiction. You would need to have separate jurisdiction over that one. So that's counterclaims. Now, let's add one other term to your vocabulary. Just make sure they're there. Plaintiff sues two defendants, D1 and D2, or P1 and P2 join suit against D1 and D2, right? Two plaintiffs, two defendants. Suppose that this defendant has a claim against this defendant. If it arises out of the same transaction or occurrence, is it called a counterclaim? No. Why should they make life easy for you? It's called a cross-claim. See, D against P is a counterclaim. D1 against D2 is called a cross-claim, and they are never mandatory. They are only permissive. So D1, if he has a claim against D2 that arises out of that same transaction or occurrence, he may bring it as part of the suit. But he may choose to keep it separate and bring another suit. He may bring his cross-claim. Once D1 brings his cross-claim against D2, now guess what D2 has now become? A person defending against a claim. And since D1 has brought a claim against D2, D2 is defending against that claim. If D2 has a counterclaim, D2 against D1 would be a counterclaim. D1, who initiates this, would have a cross-claim, but once that's brought, then D2 back against D1, it's a counterclaim, not a cross-claim. I'm sorry, it's not that much language, but it's kind of crazy language, right? So, defendant back against original plaintiff, called counterclaims, compulsory or permissive. D1 against D2, called cross claims, only ever permissive. If D2 then wants to go back against the original defendant, it's going to be a counterclaim again. If one of the defendants wants to bring in a third-party defendant, like we were talking about, hey, if I'm liable to the plaintiff, you're liable to me. Well, this person is not a cross claim or a counter. It's a third-party claim, right? So that's a different language. Isn't it fun? Okay. In addition to which, we have plaintiff against defendant, and we have this person off here. He's not party to this lawsuit, but he says, wait a second, this dispute between P1 and between P and D is affecting my rights. I would like to intervene. And that's Rule 24. Someone who is not a party to the case who wants to, says, my rights are going to be affected by this case, can intervene in the case under Rule 24. Sometimes gets supplemental jurisdiction, sometimes doesn't, sorry. Okay? And I think that's enough. We're not done. I'm not going to lie to you and tell you there's no complexity to this. I'm going to tell you you can master this as long as you don't think you have to do it in one day, okay? So you think about this. What the goal of the federal rules of joinder is to bring into one setting, one trial, one judge, things that really are efficiently tried together. That's the goal, right? Hey, if every separate little claim has to be a separate suit with a separate jury and a separate judge and all that, it's going to take 1 billion years. But if we have 15 people and they're all fighting over this one automobile accident, and we can have it all decided with one jury in one trial, it's going to save us a lot of time. So the rules are designed to get things that really are more efficiently decided together into and under the rule of one case so that the one jury can decide them or the one judge can decide them and the judge knows what's going on. So that's the purpose of all this, right? To allow for relative efficiency. And that's why we look for whether things arose out of the same transaction or occurrence, so we know what it is we have to prove. And another term that you're going to see in these rules is there a common question of law or fact, right? If there are common questions of law or fact, why have 6 different judges decide them? Why not have one judge decide those common questions of law or fact? So if we have the same transaction or occurrence, or we have common questions of law or fact, that's a reason to bring the things together into one suit. And if we don't have either a same transaction or occurrence and we don't have any common questions, that's a reason to say there is no efficiency here, so we don't have to bring them together. That's the rules of joinder, put simply. You read the details, but I think they'll make sense if you understand the purpose of it all. Okay? I think. I hope. So, I'm not going to discuss class actions or shareholders' derivative suits. I think that adds a level of complexity that we don't need yet at this point. Now, is that a hand?
I need yes.
Okay, what the heck? Go.
Okay. So like for today, you know how like earlier today we did nothing but or not property, but like common law essays where we walked through it together. Are you going to do that for like let's say something for like Civ Pro?
Yeah, I am.
Okay. Like dedicate a Saturday to.
Yeah, I am.
Okay.
Yep, absolutely. Absolutely. We can do that for everything. Okay. Now, in addition to the pleadings and the rules of joinder, there are some motions that we need to be aware of. What is a motion? Well, this is a motion, isn't it? I'm moving, right? That's a motion. But motion actually is a distinct term in the federal rules. It means any request by a party to a judge asking the judge to make an order. So if I say, Your Honor, I'd like you to make an order, that's a motion. Doesn't have to, I mean, we have a bunch of motions that have names. There's 12B1, 2, 3, 4, right? But I can make a motion that has no name. Anytime I ask a judge to make an order, that's a motion, okay? Now, some of the most important motions are these motions 12B1 to 7. These are motions that can be made before an answer is made or can be included in the original answer. 12B 1, 2, 3, 4, 5, 6, 7. And look at this, of all things, 12B 1, 2, 3, 4, 5, 6, and 7. 12B1 is a motion to dismiss for lack of jurisdiction over the subject matter, jurisdiction over the persons. Subject matter. Person, I'm mixing them up. Yeah, that's subject matter, right, that's the one, right. Whereas 2, 3, 4, and 5 all have to do with service process, or venue, or jurisdiction over the person. That's why I shouldn't have gotten that mixed up. Motion to dismiss for failure of jurisdiction over the subject matter can never be waived. You know that from the Motley discussion that we had. If I don't object to the lack of subject matter jurisdiction at the very beginning of the case, I don't waive it because I can't waive it. It doesn't belong to me. It's part of the Constitution. So I make it, that's fine. If I don't make it, I don't waive it. But 2, 3, 4, and 5 are totally different. Very important you be aware of this. 2, 3, 4, and 5, again, the order is 2 is jurisdiction over the person, 3 is service process, 4 is venue, something like that. 2, 3, 4, and 5 are all motions to dismiss for lack of personal jurisdiction, lack of proper service process, lack of venue, and stuff like that. Those motions, if they are not made at the earliest possible time, are waived. They're gone. They're dead. Because I have a right not to be required to defend if a court has no jurisdiction over me. I have a right not to be required to appear if there was no proper service of process. I have a right not to have to appear if there's no venue. But that's a personal right, and I can waive it easily. As opposed to subject matter jurisdiction, which does not belong to me, but belongs to the whole constitutional system of powers, right? So 2, 3, 4, and 5, if they're not made in the very first paper that you file, either as a motion or as an answer, are waived. They're gone. They're dead. 1 is never waived, and 12b-6 is never waived. 12b-6 is a motion to dismiss for failure to state a claim upon which relief can be granted. In other words, you don't have a case here. It's really very similar to what we were talking about earlier with a motion for summary judgment. What's the difference between a motion under 12b-6 to dismiss for failure to state a claim and a motion for a summary judgment much later in the case? It's really easy. Motion to dismiss under 12b-6 only looks at the pleadings and nothing else. It says, I'm looking at the plaintiff's complaint. Your Honor, look at the plaintiff's complaint. If what the plaintiff says is true, and you make every inference you could possibly make in favor of the plaintiff is still not alleging a claim where there's any relief. Plaintiff says, defendant looked at me unhappily and caused me to cry. I want $1 million worth of damages. 12b-6 granted, because there is no cause of action for looked at you cross-eyed and made you cry. That's not something upon which relief can be granted. That's not anything, right? We need something more. So you can dismiss under 12b-6 just looking at the plaintiff's complaint and nothing else. To grant a motion for a summary judgment, we don't look just at the plaintiff's complaint, but at the product of the discovery process, including affidavits. We look at answers to interrogatories, we look at depositions, all the products of the discovery process, plus any depositions parties make to us. In light of those things, should we grant a summary judgment? Suppose I file a motion on behalf of the defendant, 12b-6 motion, and I attach to it some affidavits. That gets converted from 12b-6 into a motion for summary judgment. You can't look at anything on 12b-6 other than the pleadings. That's the end. Summary judgment is when we add things to it. Okay? So, we now go through, oops, did I? Oh, I did, okay. I want to do it incredibly briefly. Say, after we go through these motions, are we ready for trial? No. But stepping back, it's not just because I find it interesting in history, but I think you'll understand it better. I told you earlier in the course that before the modern times, we actually still had separate courts of law and equity in most of the states of the United States, and in federal courts, the same judge would be a judge of law and of equity. But he'd sit, hey, today I'm a judge of law, tomorrow I'm a judge of equity. What the federal rules of civil procedure did was they abolished the distinction between law and equity. They said, from now on, we have one civil action. Law and equity are merged together into one system. And when they merged them together into one system, one of the things that happened was they took things that had been part of equity and added them to the seen for long. Equity had all these things that we now call discovery, right? They had depositions, they had interrogatories. All those things came from old courts of equity and were now added in to what was available. It didn't matter whether it was a case for law or equity. And what we're trying to do now with discovery, disclosure now beforehand, and discovery is not wait until the trial and have people be surprised, but try to get an exchange of information before the trial that will allow for the possibility maybe we're going to settle this thing without even having to go to trial. Maybe we're going to discover there is no genuine issue of material fact and not waste time with the trial. So we want a system of discovery where each side has to disclose to the other what evidence they've got, so we see if we really have a dispute and what it is. At the end of that discovery process, that's when we would typically see a serious motion for a summary judgment saying, in light of all the product of discovery, which might fill a file this big or might fill a warehouse the size of whatever, right? Might be a huge amount of material, but we point to the judge. We can't say, Judge, look at all that stuff. We have to point to the specific stuff in the discovery process. There is no genuine issue on the question of whether the defendant caused the plaintiff's harm. There's no evidence of causation. There's evidence that the defendant had a duty. There's evidence the defendant had breached the duty. But there's no evidence whatsoever that that breach caused the harm to the plaintiff. Therefore, I should get a summary judgment. Right? That's what we're looking for. When we get past summary judgment, now we are ready for a trial. Now we are ready for a trial. And if one of the parties requested a jury trial, and they had to do it within 14 days of filing the case, they requested a jury trial. Now we're going to have a jury trial. Now the interesting thing is, our rules of procedure also are our rules as to where we create new law. Common law, where does common law get created? It gets created when we have a motion to dismiss under 12b-6. Your Honor, the plaintiff's complaint does not state a claim upon which relief can be granted. Okay, maybe we do, and we create a new cause of action called, we're going to create a new thing called intentional infliction of emotional distress. We're going to create a new thing called malicious interference with business relations. We're creating new torts all the time. We're creating new rules of contract law all the time. And where do we create those new rules of law? Well, we could create them in the legislature, but judges create them, and judges create them at these important procedural points in deciding whether you should grant a motion to dismiss under 12b-6. Whether you should grant a motion for summary judgment depends on what's the law. Is there a genuine issue of material fact given what the law is? And the judge says, look, the law requires these 5 elements, and you don't have any evidence on this element. Dismissed. Goes up to the Court of Appeals, and the Court of Appeals says, you're wrong, we don't have that element anymore, we're removing that element. You used to need privity, we no longer need privity, whatever. That's where law gets made, in deciding 12b-6 motions, in deciding motions for summary judgment, in deciding motions for judgment as a matter of law. That's where the trial court gets to tell us what they think the law is, and if it gets appealed, that's where the Court of Appeals or the Supreme Court tells us whether they were right or wrong. So all those cases you were reading in your first and second year were all decided at some procedural junction, which is why many of your professors probably said, I want to know what the procedure was at that point. Why? Because that's where the law was made, and they're trying to make you be aware of that's where the law gets made. Okay? So we go to trial, and I already talked about this. Plaintiff puts on plaintiff's case, then we have a motion for judgment as a matter of law. Then defendant puts on defendant's case, then we have a motion for judgment as a matter of law. Then the judge gives the jury instructions. And before the judge gives the jury instructions, he's going to let the parties suggest instructions, then he's going to tell the parties what instructions he intends to give. And you're representing the plaintiff or defendant, and you disagree with one of the judge's instructions. That's when you're going to tell the judge, Your Honor, I think you're giving the wrong instruction. Here's why. So you have that issue to take up on appeal if you need to. Jury instructions, then the jury comes back with its verdict, and then we have these 2 kinds of motions. Renewed motion for judgment as a matter of law and or for a new trial, appeal. Once we get that final judgment entered, generally you can't appeal until you get a final judgment, except, just like with the rule against hearsay, there's a whole long list of exceptions. There are times when you can get an appeal before you get a final judgment. And so what do you think they're most likely to test you on? What are the exceptions to the requirement of final judgment? So read all of those exceptions carefully. And when you're on appeal, there are different standards of review. Just like I talked about in constitutional law, what's the approach that the Supreme Court's going to take to reviewing what other branches of government have done? How does the Court of Appeals review what happened at the trial court level? Sometimes they review it saying that we will only reverse if the trial court judge abused her discretion. Sometimes the Court of Appeals will say, we will only reverse if the trial court judge made a decision that was clearly erroneous. Sometimes they're going to say, we will review what the trial court judge did de novo. What's the standard of review that the Court of Appeals will use in relationship to what the trial court did? One question on your exam. Probably no more than one. Know what the different standards of review that the Court of Appeals will use on appeal of what the trial court did. Okay? Again, that's, I'd say, one question in all likelihood on your exam. And we're going to see that come up a number of times. After we have our final judgment, time for appeal is over with. That's when, and I already talked about this about as much as I'm going to, I now have a judgment, piece of paper. Time for appeal is run, I have this judgment, and I can take it to any state in the United States and say, I am suing on this judgment in your state, and the state has to give full faith and credit to this judgment and allow me to enforce against property that the defendant has in this state. With very rare exceptions, can't relitigate anything. And any opinion that was handed down the case is precedent for later cases. Plus, we have res judicata and collateral estoppel, and that's the end of procedure. Start at the beginning. We have to select a court. Who's going to make the decision for us? Plaintiff is the one that initially does that selecting, right? Defendant may get to change things later on. But at the beginning, plaintiff, your plaintiff's attorney, what state do I want to go to, or what federal court do I want to go to? What's available? What places can get power over the person, jurisdiction over the person, meaning there's a statute, a long-arm statute or whatever, to allow me to get jurisdiction over that person, and the state has power under the due process clause, either because we can serve the person in the state or because the person has minimum contacts. If I can get power over the person, then I also have to decide, do I want to go to a state court or a federal court, and know that I can only go to a federal court if I have federal subject matter jurisdiction, either diversity or federal question, and be aware then once I initiate that case there may be supplemental and removal and all those other things, and what law is going to be applied under Erie, with a tiny little caveat of what court has venue, minor point. Now I've picked what court I want to go to and I'm ready to start the case. Now, I do service of process. How do I carry out service of process? Read the alternative ways that the federal rules allow you to carry out service of process. That's right in Barbie's outline that lists 4 or 5 different ways. And what are the pleadings that we need? Not much. Complaint, answer, reply. And what needs to be in them? Not much, but there's certain things that must be specially pled. Read those. Something that I didn't mention in my last go-around was sometimes we supplement pleadings later on. Things happen later. We can supplement pleadings. Or even, this is probably one of your 200 questions in July, we can amend pleadings. Sometime later on we discover something new and we want to amend the original pleadings. Hey, can we do that? Yeah, we can. Very often can do that. What if we want to amend pleadings to bring a claim against a different person? What if the statute of limitations is run against that claim against that person? Can we get relation back of our amended pleading so that we don't lose out under the statute of limitations? We'll read that rule. That's going to be highly likely in terms of testability. Joinder of parties and claims. All those rules and all those terminologies, we'll go over those a number of times. Counterclaims, permissive compulsory counterclaims, cross-claims, third-party claims, intervention, all the different labels. Just get comfortable with them, right? And tie them back to supplemental jurisdiction, discovery. What are the different kinds of discovery? Read all those rules. It's a shame, but you're going to have 1 or 2 questions, and they're from somewhere in there. And I'm not saying memorize every bit of detail in there, but read through those rules on discovery. It's something you want to be very familiar with anyway, because when you need it, you want to know where to look. And then we get to trial, a summary judgment. Summary judgment is probably 2 or 3 questions. Trial is going to be 2 or 3 more questions. Jury, when do we get jury? What do we have to do to assert our right to a jury trial? How many members on the jury? How is jury selected? Those things. Motions made during the trial for judgment as a matter of law, after the trial for renewed judgment as a matter of law for a new trial, appeals, and res judicata collateral estoppel. And that's the whole civil procedure.